Okay, we'll start off with House File 3436, Representative Knobloch. I will move to lay over House File 3436 for possible inclusion in the omnibus bill. Representative, do you have a DE2 amendment?
Mr. Chair, I have the DE2 amendment, and I'd appreciate you moving it so I can get the bill in the shape that it needs to be.
Okay, the chair will move the DE2 amendment. All those get it in the shape the author wishes. All those in favor say aye.
Aye.
Opposed? Representative Knobloch, you may continue.
Well, Mr. Chair, members of the committee, I'm here with my co-author, Representative Hillstrom, on House File 3436. As amended, House File 3436 returns our policies on having audio and video in the courtroom to what they have been for decades. That is a requirement that absent agreement from the defendant, the victim, the prosecutor, witnesses under subpoena, and the judge, there cannot be publicly available video and audio in criminal cases. This policy has served us well for decades and should be continued. To hold criminals accountable, law enforcement officers and prosecutors must have the cooperation of victims, witnesses, sometimes children, and certainly jurors. Media coverage by its nature hinders this cooperation, making it less likely that testimony that is needed is given. If reporting a crime means the world can watch a report on the 10 o'clock news or see it forever on YouTube or elsewhere, some victims and witnesses will decide it's just not worth it. Media coverage adds nothing to the truth-finding process of the courts. The courts are public. They are open. The media covers the courts daily. Defendants, witnesses, and victims can and frequently do talk to the media outside of the courtroom. But by its nature, the most media-worthy cases will also be those that are the most heartrending for victims and families. Will a young woman who has been sex trafficked want to testify about what happened and what she did, knowing her testimony will live forever on the internet, always available to a future spouse or boyfriend? Should a mother have to hear the details of her child's murder over and over again on the 10 o'clock news? What public purpose does this serve? Even less salacious cases will sometimes involve people who are shyer by nature and less willing to have their words and faces publicly exposed. The primary purpose of the court is to find the truth and render judgment. Media presence in the court does nothing to help the courts fulfill this primary purpose, but has every possibility of hindering it. Please support our justice system by supporting House File 3436 as amended, and I yield to Representative Hillstrom for any comments she'd like to make.
Representative Hillstrom.
Thank you, Mr. Chair and members. Members, I'm a co-author on this bill because I too have concerns about cameras in the courtroom and when it's appropriate and when it's not. But ultimately, under Minnesota law, the legislature, we pass rules and laws, unless it's substantive, a substantive right to a defendant or victims, the court rule would trump state statute. And so I believe that it should be a substantive right for the defendant to waive or not, and a substantive right for the victim to waive or not. That's why I'm a co-author on this bill, and I would stand for any questions as well.
And we have, Mr. Chair, a couple of witnesses. If you want to go to that now, or we can take questions at your pleasure.
Why don't we move forward with witnesses?
Okay.
Caroline Palmer. Welcome to the committee. Please state your name for the record and proceed.
Thank you, Mr. Chair. My name is Caroline Palmer, and I'm the Public and Legal Affairs Manager at the Minnesota Coalition Against Sexual Assault. And I'm here today to speak in support of this bill and to thank Representative Knobloch, Representative Hillstrom, and yourself, Mr. Chair, for advancing this conversation. MnCASA has followed the issue of cameras in the courtrooms for over a decade. And while we recognize there may be some limitations when it comes to criminal sexual conduct cases, our bigger concern is the public understanding of what is actually public in the courtroom. People see courtroom coverage on the TV all the time. They don't know what the rules are. Victims of sexual assault, whether adults or children who have not reported the crime, will likely not know the procedural rules that go into media coverage of a trial. And if they see if a judicial process is potentially open, or even if there's a perception of openness, victims may be less likely than ever to report the crime. They see footage from courtrooms around the country and have no reason to believe it's not the same here. I want to say that research supports this reality. Going back to 1992, the most comprehensive study of rape in this country, called Rape in America, A Report to the Nation, found that only 16% of victims ever report. And researchers identified one of their main fears in this report as media coverage. And these findings are really supported by more recent research as well. The U.S. Bureau of Justice Statistics showed in 2010 that anywhere from 15.8 to 35% of all sexual assault cases are reported. These are still very low numbers. And other noted researchers, such as Dean Kilpatrick, who's one of the leading authors of studies on victim response to the criminal justice system, has found that the fear of the system remains a high factor for victims. Some may argue that the Me Too movement has changed this and has made reporting easier. And yeah, for some people, I think it has. But I would caution that there are many, many more victims for whom circumstances have not changed at all, and they still cannot come forward easily. Economic burdens, for example, mean that a victim cannot risk coming forward to bring their case, and they simply cannot bear the loss of income that might come with that. We've often heard and still continue to hear that victims are just seeking fame, that they're seeking publicity, that they're seeking money, that they're not believed. The stigmas and stereotypes are very pervasive. And I will say that many survivors who have spoken out have been vilified in social media, with some even receiving rape threats. So the message I think that comes back to victim survivors is that it's still not safe to come forward, and having cameras in the courtroom, I think, only is going to further the belief that there may be some risk to them. I really want to emphasize that MnCASA believes that an open and transparent justice system is really important. We believe that an independent media monitoring governing activities is very important too. But we also know that sexual assault victims still do not perceive the criminal justice system as a safe place for them, no matter how hard we try to ease that experience. And I'm not talking about the criminal courts alone. Civil courts can also be an area where people are very reluctant to come for sexual harassment cases, for sexual abuse cases, and even a protective order in a domestic abuse or sexual assault situation. At the end of the day, we just cannot risk creating any further barriers for victims seeking justice. Not only are they deterred from reporting, but we as a state are losing the opportunity to hold the offenders accountable who have created the harm. If we lived in a society where victim credibility wasn't continually challenged, I wouldn't be up here today and I would be celebrating. But the fact is, it's challenged every single day. And as long as we have that skepticism and disbelief for victims in our society, at this point we have to remain concerned about cameras in the courtroom and other media that can really influence the way victims see the system and their chances in that system. So thank you, and I'll stand for any questions.
Does not appear to be any questions at this time. Charles Hembrick. Beck.
Hello, I'm Charles Hempeck with Anna Marie's Alliance, and thank you for hearing me this morning, and thank you to Representative Hillstrom and Knobloch on putting forth this bill. Anna Marie's Alliance is a local nonprofit organization in St. Cloud working to end domestic violence through intervention, advocacy, and education. Anna Marie's Alliance is nearing its 40th anniversary as an organization, which gives us a unique perspective on the needs of the victim survivors. Our legal advocates help people understand and navigate both the criminal and civil justice systems. We meet with victim survivors immediately after a domestic violence incident, while law enforcement is still present. This helps ensure that they know what services are available to them. We follow the criminal proceedings, and in partnership with the county attorney's office, keep them informed of what is happening throughout the process. We also assist in filing orders for protection and accompany them to a hearing if requested. Last year, we attended nearly 1,700 criminal and civil hearings. Anna Marie's Alliance is also part of the Stearns County Domestic Violence Partnership, which is an extension of the Stearns County Felony Level Domestic Violence Court. This system-wide response focuses on holding offenders accountable while ensuring victims are supported throughout the criminal proceedings. Anna Marie's Alliance knows that victims are not always willing to participate in criminal cases for legitimate reasons. They are worried about their safety and that of their children due to previous threats by the offender or the offender's family. It may be challenging to take time away from work, especially if they are now the primary breadwinner for the family. They may feel ashamed or responsible for what happened, especially if this isn't the first time their partner has been arrested for domestic violence. For the majority of the women and men we work with, confidentiality is of the utmost importance. There is still a stigma attached with being a victim of domestic violence. With all the aforementioned reasons why a victim might not want to participate in a criminal hearing, I don't think we should add one more possible barrier like allowing cameras in the courtroom. Victim survivors are often dealing with many layers of trauma, and we work hard with all of the systems people involved to ensure victim survivors are not re-traumatized during the court process. I don't see a benefit to potentially broadcast the trauma that people may have to relive during a court hearing. People generally understand that defendants have rights, but victims have rights as well, and they should continue to have the right to say whether cameras are allowed in the courtrooms. Thank you. I can take any questions if you have any.
Not appear to be any questions at this time, so we'll move on to Mark Anfinson.
Good morning, Mr. Chair, members of the committee. I'm Mark Anfinson. I act as general counsel to the Minnesota Newspaper Association, the trade association of all the state's newspapers. I speak in opposition to the bill. The motives of these proponents of this bill are perfectly understandable and, in fact, commendable. We have no problem with that. What we do have a problem with is the methods the proponents are proposing to achieve their goals. What you've heard so far from both the authors and the witnesses who've testified are claims almost completely divorced from current reality in Minnesota, okay? Almost completely divorced of facts. I would like to share with you a few actual facts that will give you some context for this proposal. For the last 10 years or so, the Supreme Court of Minnesota has been involved in a very slow, tortuous, laborious process to allow cameras in courtrooms to some limited extent. I've been in the middle of that because I've acted as attorney for a group of media petitioners that have sought the court's help in liberalizing camera access rules. The court has conducted 2 pilot projects over that period of time to study the impact of cameras. One, a few years ago, it did in civil cases, and for the last 2 years, the court has been conducting a pilot project for criminal case proceedings. Okay? In the course of those pilot projects, the purpose of the court has been to acquire empirical information, in other words, facts, to assess not based on propagandistic claims about the impact of cameras in courts, but actually what happens when cameras are allowed. And the results of the pilot projects have shown that cameras cause absolutely no discernible problems for anybody in Minnesota courts. None. There is another impact, though, that has been established as well, and that is that members of the Minnesota public, your constituents, residents of this state, have for the first time in the state's history been able to see what actually occurs in courtrooms, which, if you know about that, is normally pretty impressive, but until a few years ago is completely barred to the public. And in particular, in criminal cases, the cases that typically concern the public the most, for good reason, members of the public have been able to see people who commit terrible crimes that have caused great concern among the public generally, brought before the bar of justice and sentenced for what they did. Now, all this talk about victim concern and exposure of the justice system to this terrible pestilence of cameras has, again, no basis in reality. I'm going to tell you a few points briefly. And, Mr. Chair, I respect the committee's time, but this is an important issue. Let me tell you 2 more things to conclude my testimony. One, what the current Supreme Court rule governing cameras in courtrooms actually says, what it allows and doesn't allow, which is as follows. This is the current Supreme Court rule that allows cameras in criminal proceedings, the focus of this bill, okay? The only portion of a criminal case that can be captured on camera, audio or video, is the portion of the proceeding that occurs after a guilty plea has been obtained. Nothing, none of the testimony of victims, none of the testimony of witnesses, none of the proceedings in the court during the trial are public. I'm sorry, can be captured on video or audio. Only when the defendant is going to be sentenced can cameras come into the courtroom. And that's it. Okay? No audio or video coverage is permitted at all when the jury is present in the courtroom. None. No coverage of any kind is allowed in a proceeding held in what they call problem-solving courts, which are the specialized courts that deal with drugs, mental health, veterans, and DWI. No coverage at all under the current court rule. No coverage whatsoever is permitted in cases involving charges of criminal sexual conduct or in cases involving family or domestic violence. No coverage. And no audio or video coverage of any kind is permitted of a testifying victim unless the victim affirmatively acknowledges in writing before testifying to the coverage. That's the current court rule. So what you end up with in current criminal proceedings in Minnesota under the Supreme Court's pilot project rule is that defendants who have committed terrible crimes and who are being sentenced by the court get to be shown on television or on a website of a newspaper. And the question I have for the committee and the proponents of this bill is, why is that a bad thing? What is wrong with allowing people to see a court sentence of a person who's committed a terrible crime? It's baffling to me. We're not talking here about any victims being shown, any witnesses who don't want to be shown, any portion of the trial, only that little final segment of a criminal case. Okay, now one final point. As I said at the outset, I think it's important here as we look at an issue like this that we focus on facts, not on propaganda, okay? Not on speculative claims that are not connected to reality. Minnesota has tiptoed along the path of cameras in courts now for almost 10 years. No problems have been identified. But it's still a tentative experiment. What isn't tentative is the fact that approximately 40 other states in America have routinely allowed camera coverage in all civil and criminal proceedings for 30 years. Okay? Wisconsin, North Dakota, Iowa have allowed almost unrestricted camera coverage of civil and criminal cases from beginning to end for 30 years. When the Supreme Court was considering this issue several years ago and establishing the pilot, we had a prosecutor come over from Wisconsin, a criminal prosecutor, and he testified in favor of Minnesota liberalizing its camera rules. And he was challenged very vigorously by the Supreme Court's advisory committee. And at one point in his testimony, he leaned back and he said, "Folks, quit looking for the boogeyman. There is no boogeyman with cameras." This was a criminal prosecutor from St. Croix County. So, I appreciate the motivation of the proponents. Their concerns are legitimate. But if you look at the facts, if you look at reality, and you look at the experience in Minnesota over the past 10 years as well as many other states, this bill is unnecessary. It will only hurt Minnesotans who desire to see a little bit more about what their courts do. Thank you, Mr. Chair.
Thank you. Any questions? Representative Hillstrom.
Thank you, Mr. Chair. Sorry, I had to move over here because now I'm on the committee and I get to ask questions. But Mr. Anfinson, this has been a slow creep of the court, and you've been talking about how this pilot project started off as civil and then has moved to criminal. So it's clear that that's the direction that the court is going to. And so while you may be specifically talking about the court rule as it is at this minute, that doesn't mean that there isn't a need for the state legislature to decide on a matter of public policy whether or not we should weigh in on whether or not we think victims or defendants should have a substantive right. You have made it clear that for 30 years other states have been doing this, so it's clear the direction you would like to see the state go. So, Mr. Anfinson, do you believe it's improper for this legislature to decide if a victim or defendant should have a substantive right in the courtroom with relationship to cameras in the courtroom? Or do you believe that's solely within the discretion of the court?
Mr. Chair, Representative Hellstrom, I know what you want me to say, Representative Hellstrom, but I'm not going to say it. The legislature has absolutely no right to get involved in this issue. How's that? No, that's not my position at all. Of course the legislature should have concern about this issue. My response to that question is that there's no imaginable, empirically justifiable reason for the legislature to enter this topic now. The Supreme Court has already done it. You talked about the Supreme Court's slow creep on this issue. I think that exaggerates the speed with which they're proceeding. I have been very frustrated with the court, to be candid with you. I think they should move faster and further with allowing members of the public to see what happens in criminal courtrooms. But they haven't. And the singular, overwhelming, emphatic concern of the court for 10 years has been protecting victims and witnesses. Why would anyone think they're going to suddenly change? Especially when they have a majority of Democrats on the court now. That's a shot, Representative Hellstrom.
Representative Hirsch.
Thank you, Mr. Chair. So, Mr. Anfinson, if this were reversed, if the legislature was weighing in and saying absolutely every courtroom should be open to every court, every jury should be able to be videoed, every victim should be able to be videoed, every defendant, would you be supporting that proposal if we were flipping it? Would you be saying we, the legislature, should be driving to allow you to be in the courtroom more?
Mr. Anfinson?
Mr. Chair, Representative Hellstrom, I certainly would be. And the reason I would support it is because it would be doing a great service to your constituents so they can see what good work the courts do. People don't understand how impressive the district courts of this state normally are. And they can't see that unless they can see it on television or on websites. And so the reason I would support that flip, as you call it, Representative Hellstrom, is because, again, as I've said, in 40 states for 30 years, there has been no documented evidence of any problem for anyone, including victims and witnesses. But I respect especially the victim testimony, and I don't personally have the slightest problem with placing restrictions on placing them on camera. But that's not going to happen. It's not going to happen with the court. It hasn't happened in 10 years. It's not going to happen in the next 10 years. And the other concern here, Representative Hellstrom, is we're not just talking about limiting camera coverage of a victim. This amendment that has been placed on the bill this morning demolishes any real prospect of camera coverage of criminal proceedings. That's a disservice to the residents of the state.
Representative Hillstrom.
Thank you, Mr. Chair, and this will just be my final comment. So your testimony was that the legislature shouldn't weigh into this policy. But what your testimony should have been is the legislature shouldn't weigh in unless you want to expand the cameras into the courtroom, because that is what you just said. And so I believe that is the role of the legislature to make a determination on whether or not we believe that victims and defendants have substantive rights with regard to this issue. Whether you agree with how far it should go or how far it shouldn't, it is the role of the legislature to decide what rights people have. And I'm just going to stop there.
Representative Becker-Pin.
Thank you, Mr. Chair. So first, I just want to say that this isn't a joke. What happens in a criminal proceeding is a very serious thing for the parties directly involved. And I understand that it can be entertaining or interesting to people, but ultimately I think that our justice system should be focused on achieving justice. And I think that your testimony particularly is a prime example of how people act differently when they're performing for the public or believe that the public is watching. And so I think that, you keep saying that nobody has a problem with it, and that you respect the testimony of the prior testifiers, but those things, that doesn't even make sense. If you truly respect the testimony of the prior testifiers, then you would give their testimony credence. And you don't speak for the advocacy community, and they've spoken well for themselves, and I think that we should all listen to what they're saying about the effects. And so if nobody has a problem with it, which is what you're saying, that nobody has any problem with the cameras in the courtroom, then why not allow the people directly involved to decide whether they want the cameras in the courtroom? Because apparently nobody has a problem with it. So if nobody has a problem with it, then we may as well let the people directly affected share their opinion about whether they have a problem or not. So I think, it's disingenuous to state that nobody has a problem with it, and it's disingenuous to undermine the testimony that we just heard from the advocacy community.
Mr. Chair.
Mr. Anfinson?
Representative, you mischaracterized my testimony. You do so in a fairly fundamental way. I never said nobody cares. What I said was there are no facts that have been acquired in 30 years of extensive camera coverage in this country showing any of the impacts, in fact, have happened that the proponents of the bill describe. I care deeply about the victims. I have spent hours and hours and hours over the last several years in promoting camera coverage through the Supreme Court and talking to victims advocates who have convinced me this is a big issue, and I respect it deeply. And it's not my testimony as you've described it. This is a big concern. But when you talk about why shouldn't the people affected be allowed to decide, who is affected when there's a serial rapist at loose in the community? Who is affected when there are murderers killing children in the community? Is that just the victim? Is that just the witness? Or is it the community itself who's affected? And when you see a person who commits a terrible crime like that brought before a court, brought before a district court judge, and sentenced to life in prison, that provides an enormous community benefit. Those are the people affected. It's a huge catharsis. It's reassurance that our justice system works. It's a demonstration that we live in a society that gets people like that and puts them away. That's the benefit of the camera.
Representative Frankie. Representative Becker-Finn.
Thank you, Mr. Chair. And to clarify, you previously stated that nobody has a problem with it. I never said that you said you didn't care.
I didn't say no one has a problem with it.
Representative Becker.
Thank you, Mr. Chair. In the committee, we talked through the chair. I know.
I understand the protocol.
Mr.
I also
Anfinson, let's-
understand we're supposed to properly summarize the testimony of a witness.
Mr. Anfinson, you will speak through the chair. You will speak when you're asked to.
I appreciate that.
Representative Becker-Finn has the floor at this time. She will start talking. When she is done, I will let you have a chance to respond.
Mr. Chair, I apologize to you and the committee.
Thank you,
Representative Becker-Finn.
Thank you, Mr. Chair. To be clear, court hearings are, for the most part, public already. Many of the people here in this room and here at these tables have been present at court hearings. We certainly know who the criminals in our community are. When I'm not in this building, I spend my days in the Hennepin County Government Center, and we've all seen the pictures of the people leaving the courtroom. We've all seen the video of them walking across the Government Center, walking across that federal area in front of the federal courthouse. We all know who those people are. The lack of cameras in the courtroom hasn't stopped us from knowing who the criminals in our community are. We all have seen mugshots. The idea that we're somehow shielding a rapist or a murderer by not allowing a camera in a court proceeding is ridiculous. So again, we need to be focusing on justice and achieving justice for the people who are directly affected by court proceedings. And if there clearly nobody has a problem with it, then I don't see how it's a problem to let the people directly affected, members of the public, the defendant, the victim, the prosecutor, who represents the state and all of us, make that decision.
Mr. Chair? may I
Mr.
respond?
Anderson?
Again, Representative, with respect, I think you misdescribed my testimony. I'm not saying the lack of a camera in a criminal courtroom shields anybody. What it does is provides a reassurance, a catharsis, a demonstration of how the justice system works. And that has enormous value to the people whose court system it is, after all. This isn't about grandstanding for the cameras or increasing ratings. None of that happens. All I can do, I'm not going to take the committee's time to correct what you've said I testified to as opposed to what I did. Everyone's heard what I said. I go back to the central premise, which is nowhere in the United States is there a documented study showing that camera coverage of criminal court proceedings does anything that harms victims or witnesses or the system of justice itself. There's plenty of evidence, however, that people appreciate the ability to see what their courts do. And I will also say it's a benefit to the courts to have this public access. There's a reason the Supreme Court is proceeding down this path. Because number one, it's been gradually persuaded that there are no serious negative impacts. And number two, and equally as important, the court, I think, is being persuaded that it benefits the courts to have greater public visibility and engagement, which can only come through a camera. After all, the cliche is still true here. A picture is worth 1,000 words. And in certain types of complex legal proceedings like criminal cases, that's clearly true.
Okay, members, we do have a number of bills to go, so I do ask that you, with your comments, keep them short, because we do have session at noon. Representative Frankie.
Thank you, Mr. Chair. I just wanted to make a brief statement to something Mr. Amundson had said. You don't really need to respond to this, Mr. Amundson, but the shot at the Democrat courts and Democrats insinuating that this is a partisan bill, and people understand that this is brought forward by the chair of Ways and Means, who is Republican, and co-authored by Representative Hillstrom, who is DFL. I just think that needed to be reiterated and pointed out that even though sometimes I would like to take shots at the DFL myself, this was not the appropriate time to do so in context with this bill. So to remind people that this has bipartisan support. Thank you.
Mr. Chairman, could I respond to that? I'll be brief. Mr. Chair, Representative, it is always a treacherous gambit to use humor either in a courtroom or a legislative hearing. And I have testified here for 30 years. I understand that better than most people. I nonetheless occasionally try and inject a little humor. Not because I have any disrespect for the authors of this bill, not because I have any respect for the court. I didn't seriously mean that a Democratic Supreme Court would be different on this than anyone else. And Representative Knobloch is well known as a Republican to me. This is a bipartisan bill. And it's nice to see that over here. But in no sense that I mean disrespect or suggest this is some kind of a partisan effort. It's not. I know that.
Representative Constantine.
Thank you, Mr. Chair. And please don't respond. If somebody wants to see how well our district courts work, they can simply drive down and sit in the back. This is reality TV, and that's all it is. Thank you.
Okay, next on the list is Sonia Miller.
Mr. Chair, can I just say something to this?
Representative Knobloch.
Well, first, Mr. Chair, members, Mr. Anfinson, I was listening very close to his testimony, said, quote, "No problems have been identified," unquote. But members, there actually is a Minnesota Supreme Court Advisory Committee on Rules of Criminal Procedure that issued a report in December 2017, and a minority of the members, 6 of them, were against extending the pilot project on cameras in the courtroom. And let me just briefly quote from the report. It said, members who oppose permanent codification note that coverage under the rule is unfair to defendants because they do not have the same right to deny coverage as victims do. The presence of cameras distorts the process and that people may behave differently due to the presence of cameras, and brief coverage of sentencing hearings sheds no real light on what happens in the course of a criminal case, provides no real public educational value, and creates more work for those involved. Finally, members opposed are concerned that permanent codification of the cameras in the courtroom pilot rule may lead to a slippery slope expansion of coverage. So Mr. Anfin says, well, no problems have been identified. Here are 6 people on the Supreme Court Advisory Committee of Rules of Civil Procedure who have, in fact, identified problems. And finally, Mr. Chair, in the St. Cloud Times on March 28, 2016, Mr. Anfinson was quoted, the domestic violence exception to the current rule has proven to be, quote, far more applicable in the view of judges than I expected it, and I think more applicable and problematic than the Supreme Court anticipated, Anfinson said. That exception is, quote, depriving the public from a lot of information about some of society's worst crimes, he said. So clearly Mr. Anfinson's desire is, even though the rules as they are quite constricted, it is his desire and that of his organization he represents to greatly expand this to domestic violence and other cases.
Mr. Chair, can I respond to that last comment? Because
Mr. Hanson, I'll give you about 30 seconds.
That's
We
all
have
I'm
a-
gonna
We have
say.
a lot to do yet, and we have session in an hour and 5 minutes.
Mr. Chair, I respect that. Again, it's an important issue. In terms of that quote in the St. Cloud Times, and of course we have to assume the St. Cloud Times correctly quoted me, but I think they did. My point, which I would make again today, is that certain terrible domestic crimes are being completely excluded from camera coverage because of the breadth of the rule. I'll give you the quick example. A couple of years ago, a man murdered his wife and cut her body up and put her in a freezer. And he was eventually found and convicted of murder. And his sentencing, again, all we're talking about under the current rule is the sentencing. The sentencing of this man was prohibited under the current rule because it was a crime of domestic violence. That was the only point I was making. In no sense do I believe that the court coverage of cameras in domestic cases normally should be expanded.
Representative Pinto.
Thank you, Mr. Chair, and I'm sorry. I thought that you'd seen me before, so my apologies. I just want to build on Chair Knobloch's point that that it's striking to me that even this really small rule that Mr. Anfinson is talking about, even that is opposed by a number of people looking at it, giving the reasons that the Chair Knobloch provided. On the other side, if members look at the report, the support for expanding the rule is, well, in general, we haven't seen too many problems. And I found it really striking in Mr. Anfinson's testimony that I believe he said there are no serious negative impacts, and on the other hand, it benefits the courts. And I find that striking that it does feel to me that we can be focusing a lot on this individual narrow rule, but it is clear in the testimony that the hope is that the path, we do continue down this path, that we do have a flip, so that we do have this, we are expanding this. And when you look at the reasons for it, there doesn't seem to be much of a benefit for public education for this narrow piece. And of course, the argument's going to be made that we need to have more and more of it. And then on the other hand, the negative consequences come more and more. And finally, I'd just like to point out, has been made before, courtrooms are open. I've had many trials as a prosecutor. I cannot think of a single trial where it was closed, where members of the public, anybody who wanted to, except for, I suppose, people, there's people who were witnesses in the case, could not sit in that courtroom and know what's going on. Courtrooms are open, and they have been open for many, many years and will continue to be. Thank you, Mr. Chair.
Thank you very much, Mr. Chair, members of the committee.
Sonia Miller. Please introduce yourself. Welcome to the committee.
Thank you. Good morning, Mr. Chair and members of the committee. My name is Sonia Miller Van Ort, and I'm here today in my capacity as president of the Minnesota State Bar Association and its 15,000 members. I'm here today, as I understand the legislation that's been proposed and even the amended version that's been posted, to speak in opposition to the bill. What I want to clarify first is on the substantive issue that you've been hearing testimony on regarding the use of cameras in the courtroom. On that particular issue, I can inform you that the MSBA took a vote yesterday, and its position to the Supreme Court will be opposing the continuation on the permanency of the camera in the courtroom for criminal proceedings, which has been a pilot project that you've heard about. So on that substantive issue, the MSBA is in alignment with the legislation that you're looking at. Reasonable minds can differ, certainly. You've heard different viewpoints. But on the substantive issue, our association is in agreement. So the question is, why am I sitting here then today? Why am I opposing the bill? The reason that the MSBA has asked to be present today is to voice a separate concern concerning the bill. And that is that as written and even as proposed in amendment, it calls into question a significant impact to the separation of powers on which our country and our state is fundamentally principled. As you all know, and I think about this when I go to schools and I speak to school children, as probably many of you have done, and we talk about separation of powers, and we explain to children that there are 3 branches and that each one of those institutions has its own responsibilities of governing and operating 3 distinct areas: the executive branch, the legislative branch, and the judiciary. And when we explain that to children, we explain that that's because we want a balance of power, and we want those different branches governing those things that fall under those different branches. And we know, and we tell our children that this is a great way for government to exist, because it inspires trust in the public to know that there's a checks and balances. And that even when we've got different people in leadership that people agree with or don't agree with, they can still have comfort in a system that we have of checks and balances and separation of powers. So the concern that the MSBA has with the legislation, again, is not the substantive issue, but what the legislation seems to be suggesting is that it would be appropriate for the legislature to dictate to the separate branch of the judiciary how it should conduct its business and how it should govern the administration of justice, which is its primary function. It's in that way that we have a concern. The judiciary has a process. They are responsible for courtroom rules, decorum, how justice is going to be carried out in that courtroom. And it's a difficult job, but that's what they're taxed with. And this legislation seems to take some of that power away from the courts and to say instead the legislature should decide how the judiciary branch should carry out that business. So simply on that basis, it's a philosophical basis, it's a fundamental basis of our government and the legal principles supporting it, that the MSBA respectfully requests that you reconsider the legislation that's before you and how it's been styled and formed, and to think about how that impacts the separation of powers concept and what message that sends in undermining the judiciary and in some ways even undermining the fine legislature and all the wonderful things it does in its area of expertise and potentially undermining the public's confidence in our system. Thank you. I'm open to any questions if there are any.
Representative Hillstrom.
Thank you, Mr. Chair. We had a conversation before the committee hearing started, and I understand that you're in alignment with the lack of cameras in the courtroom. So do you believe that we could address that issue by simply making it a substantive right for the victim and the defendant? Would that take care of your separation of power issue?
Potentially. I guess without seeing exactly how it's been drafted, I can't respond completely. The issue, I think, the check, what we're suggesting we need to keep in mind is, does what the legislature create impede on the judgment of the court and how it's carrying out the administration of justice? So there may be a way that the legislation can be written where that doesn't happen, but that's our concern. And that would be our concern regardless of substantively what was in the bill.
Thank
Thank you. We have one more witness, Mr. Hal Davis. While he's coming up, I'll remind members that we have 4 bills to go, and we are in the process of reserving a room for tonight at 8 o'clock if we cannot get through that.
Mr. Chairman, members, my name is Hal Davis. I'm a member of the Legislative Issues Committee of the Minnesota Coalition on Government Information. It's my first time testifying before any legislative committee, and I'll try to observe the protocols. We oppose HF 3436 as amended. Minkoji supports expanding cameras in Minnesota courts as a way for the public to see what happens in its courtrooms. Cameras let the public observe government officials perform important duties that only a select few can witness in person. Such coverage provides the public with information vital to its role in a functioning democracy and helps ensure that the information disseminated is more complete and accurate. You might say it's the best evidence. As Minnesota Supreme Court Associate Justice David Lillehog recently said, the more transparent and accessible the courts are, the greater the trust in the judicial system will be. As the Minnesota Supreme Court will soon face a major decision on cameras in its district courtrooms. For the past 2 years, the pilot project has allowed news organizations to capture video and photographs inside some sentencing proceedings, and they'll soon decide whether to make that policy permanent. Minnesota stands out among its neighboring states. Citizens in Wisconsin, Iowa, and North Dakota are accustomed to seeing televised and photographed court action. In many other states, cameras are a routine sight at the trial court level. Several states, including Minnesota, have studied the impact of electronic media coverage on courtroom proceedings. Nationally, it's been reported that the extensive empirical evidence that has been collected on the impact of electronic coverage has established that such coverage is not detrimental to the parties, jurors, counsel, or courtroom decorum. The Minnesota Supreme Court Advisory Committee on Rules of Criminal Procedure assessed the 2-year pilot program. They reported no disproportionate minority representation, which was a major issue. Disruption to criminal proceedings was overall is minimal. Audio and visual coverage provides greater public exposure to criminal proceedings, which increases the appearance of transparency. And the overall impact on the proceedings was neutral to positive. In some cases, crime victims welcomed camera coverage. A man in Le County, whose wife plotted to kill him, agreed to be photographed and videotaped as he read his victim impact statement. He wanted people to know what he and his daughter endured. Minkoji believes it's time to let the people see what goes on in the people's courtrooms.
Thank you. Members, we are going to be laying this bill over so we can have more discussion on it later if we need to. Representative Knobloch, do you want any final comments?
Well, I just want to thank you, Mr. Chair, and members of the committee. Thank you, Representative Hillstrom, for co-authoring the bill with me. I know this has taken a lot of time, but this is a very, very important bill, and so I appreciate your attention, and as it goes forward, I would appreciate your support. Thank you.
Thank you. With that, I renew my motion to lay the bill over for a possible inclusion as amended. All those in favor say aye. Aye. Opposed? Thank you, Representative Knobloch.
Thank you, Mr. Chair.